Hello, welcome to our training in the area of franchisee crisis. Today we will be giving you some insight into practical and legal steps to consider when a franchisee crisis happens. Hello, I am Fiona Boswell, a partner and franchise specialist at Knights. I am a qualified franchise professional with the British Franchise Association. I am a notable practitioner in Chambers for Franchise Law, an author and contributing editorial board member for LexisNexis, a contributor to the Elite Franchise magazine, which is a specialist franchise publication. I've been EWIF Service Provider of the Year, which is a voluntary organisation which supports women in franchising, and I am the Midlands Regional Chair for that organisation. I'm also a judge for the Top 100 UK franchises and have been so for the last 8 years, and I'm a former British Franchise Association External Relations Committee member. At Knights, we have a multidisciplinary franchise team, which means that we cover all aspects of franchising, from your contracts to advice on strategy, transactions such as acquisitions and disposals of franchises, property aspects, anything to do with taking a lease or an assignment of a lease, anything to do with employment issues, HR, staffing issues, worker rights, contractor issues, litigation such as disputes, dispute resolution, any licensing or regulatory requirements that franchises have and need to comply with, tax issues associated with franchising, and we also deal with the data protection and AI aspects of franchising. We're a national firm. We have clients all over the country, and we have offices throughout the country as well, currently standing at about 26 of those. We are advisor members of the British Franchise Association, and we are also members of EWIF, the national voluntary organisation which supports women in franchising. We are on the HSBC Franchise Bank panel, and we principally advise established and emerging franchisors and also franchisees that operate multiple brands or multiple units of franchises. We provide practical legal advice for your journey in franchising. In this training, we will be covering three main categories. Firstly, the early considerations that you need to have when you start out on your franchise journey. Secondly, how to manage the franchise. And thirdly, how to prepare for your exit from franchising smoothly. Firstly, let's look at the early considerations. These are broken down into three key areas: avoiding relationship breakdown, giving security, and property step-in rights. Now, to avoiding relationship breakdown. Many franchises are co-owned with several parties involved in the franchise entity. You should carefully consider any equity split based on the contribution to the business. If, when you take a franchise, you set up a limited company, there can often be many parties involved in that entity. Or it might be that there's just a couple and effectively the business is what we would call a quasi-partnership. It is vital in these circumstances that you put in place appropriate agreements that police the relationship between the different parties in your franchise entity, and in particular that you clarify between you what happens if one or other of you wishes to leave, becomes ill, or dies. So the type of documentation that would be included here are shareholders agreements for limited companies, partnership agreements if you are a partner, and also key man insurance policies. These are policies that you would put in place on the life of a key director in the business, so that a pot of money would be paid out at the end when or if they die or become ill, that would be available to the other parties in the business to use to acquire their stake in the business per se. It is really key that this type of documentation is put in place when you start running your franchise business. It simplifies things greatly for those left behind. In this second slide, in which we are covering some of the issues that can arise early on in the operation of your franchise, we look at one of the staple forms of security that are often put in place at the start of you operating a franchise. In order to take a franchise, you are often required to give a personal guarantee. And this is usually, in particular, where you are operating a franchise as a limited company or some other limited capacity. And that is often because the company has been set up and it is at the very early trading stages, what we would usually call a newco. So when you are giving a personal guarantee, it's important that you understand this will mean that you are personally liable for the acts or omissions of that franchisee company. So most franchisees put in place franchise companies to take away some of the personal risk primarily, but the personal guarantee is a key part of that process because it is important that you adhere to the terms of your franchise agreements. But you also need to understand the significance of signing a personal guarantee, which does mean that your personal assets, your home, your car, etc. are at risk only, however, if you default on making payments that are owed to the franchisor or are in some other way fail to adhere to the terms of the franchise agreement. So it is vital that you have strict financial processes in place to make sure that your businesses are run properly and that you are able to make payments, etc. on time. And where you are involved in a business where there are a number of parties involved in the franchise, and or some of those may be your other half, husband or wife, it is really important that they also likewise understand what they are doing when they give security like a personal guarantee, and again that their personal assets may be at risk. So that it's really important that compliance with the terms of the agreement is very much central to everyone involved, and that you understand what those terms are and what the requirements are for you to pay things on time or comply with as a franchisee in the network. Because that's the best way to avoid anyone ever needing to rely on enforcing the guarantee against your personal assets. And now for the final part of our early considerations, which are to look at property step-in rights. These will apply in particular to mainly Canopy, where the brand is operated from leased or owned premises primarily. And in that situation, you need to be aware of a few things. The first being that where they're operated from leasehold premises, it is important for you to check in advance that that lease can be transferred over to the franchisor or to a third party, and that you can comply with any of the assignment or alienation provisions that will be contained in that lease. This is important because the landlord's approval will be needed to you being able to transfer that lease onto a third party or back to the franchisor. And it will be key that you can do that in order to realise the investment that you have in the franchise at the point when you want to sell. But it's something that you need to ensure is built in right at the start and not wait until that point when you want to come to do that. So To help embed some of the points that we've been discussing that are early considerations for franchisees at the start of their franchise journey, let's have a look at a case study which is based on scenarios that we have actually experienced when advising. In this scenario of case study A, there was a franchise entity, for example, a Newco Limited company, that was set up by two good friends who owned this company on a 50% basis, essentially, as quasi partners in that limited company. The friends operated the franchise together quite well for a number of years, and then unfortunately, towards the end of year 2, the two good friends fell out. Both originally wanted to continue with the franchise, but they didn't want to do so together. Unfortunately, however, they did not have a shareholders agreement in place, and negotiations between them turned sour, and one of the friends decided to leave the franchise. Although she was no longer actually working in the franchise, she still owned a 50% stake in the business, because the law says that unless there's something in a shareholders agreement or your articles of association that says otherwise, the shareholder in this scenario would still retain their shares. This meant that the remaining party was forced to have to raise funds in order to buy this party out, so that she could wholly own the business and derive the full income for all the work that she was putting in continuing to run the franchise. This example is quite key, and the main things that were missing that made it more difficult for these particular franchises was their shareholders agreement. The other thing that would have helped them make this scenario much easier for them would have been to have some sort of key man policy in place that was triggered when a person chose to exit the business. And that would then have perhaps paid out some money so that the other party could easily be bought out without additional finance or funds having to be raised. I hope this helps to just bring home some of the reasons why it's important to set up your franchise businesses well from the outset. Now it's time to move on to the next stage of growth for you as a franchisee, which is into the part of the business when you are beginning to manage the operation of the franchise. And there are a number of aspects of doing this where it is important to put some key steps and checks and balances in place. We will be covering in this section a number of areas: the topics of whistleblowing, the aspects of getting funding and finance, issues surrounding advertising and the use of social media, key points that are involved in the day-to-day operation of your franchise, issues to be aware of that may follow from insolvency, and also staffing and resource issues. First, let's take a look at whistleblowing. Your staff and/or contractors must have means to anonymously report issues in your franchise. The use of whistleblowing policies is vital to protect standards across the network. Franchise networks have recently been publicly criticised for failure to prevent staff from experiencing varying forms of harassment. It is vital that you implement a thorough review process to guarantee that complaints are listened to and, if required, appropriate action is actually taken. Failure to do this can not only negatively impact your own business, but the brand as a whole and other operating franchises. It's vital that you maintain your business with adequate finance and cash reserves. Where customers pay in advance, it's important to maintain these funds to cover the operation of the business. It's vital that you seek appropriate advice on how to structure your business finances to enable your franchise to thrive. And also use the recommended accountants that your franchisor will suggest. They will be familiar with the financial needs of businesses like yours and also be able to help in putting together proper financial plans for you. Marketing your business is definitely something that's very key for you to do as a franchisee in order for the business to grow. But it is important that any advertising or social media that you use remains consistent with brand messaging and the social media policies that are put in place by the franchisor. This will include how you use any branded assets such as vehicles or where and how you wear branded uniform, etc. You should be mindful of how use might disparage the brand and other operating franchises, such as erratic or unsafe driving in a vehicle with the brand's livery on it, inappropriate behaviour or language used whilst wearing a branded uniform, or unsavoury comments on personal social media pages that are linked to or associated with business accounts, and or potentially any inappropriate customer interactions. All adverts ultimately should be pre-approved by the franchisor. Day-to-day operation of the franchise will be set out in the operations manual that you follow as a franchisee, and in most cases this is typically digital. That manual will tell you how to do any process in the business, and it is important that you follow it and follow that model. When you do that, that's the route through to actually running your franchise business successfully, because it's the model effectively that's been followed by the franchisor and has enabled it to achieve the success that it has. That is why it is vital to stay up to date with any updates that are made to the manual, digitally or otherwise. Make time to read those and stay on top of current systems and processes. This will also ensure that you're actually sticking to what your franchise agreement says that you should do, and also that you're deriving the best benefit and the best support to help you run your franchise businesses well. Insolvency will have a significant impact on your operation of the franchise and also what you're able to do with the assets of the franchise. Insolvency events include winding up petition being presented by a creditor of the business, such as the taxman, but also you choosing to wind up the business voluntarily. And when that happens, in either case, insolvency will trigger termination of your franchise. In these circumstances, it's also important to consider what will happen to your obligations under the franchise agreement, because practically insolvency can give rise to problems with accessing the assets of the franchise, including any premises that you own or you lease or are otherwise occupied by the franchise. And it may also cause issues in use of physical equipment which you own or lease as well. It could also result in your right to use or occupy premises coming to an end. So it has quite a significant impact on your ability to operate the business. It should be an option that is chosen as a last option and a very last resort, and only under the guidance of a registered insolvency practitioner. And in circumstances where you are not choosing it and it is a creditor choosing to wind you up because you owe them money, please ensure that you get appropriate advice. And so to our final slide of the managing the franchise section, resource issues. Keeping information that is proprietary to the brand, such as customer details and know-how of the system, is critical. Where you use contractors or temporary staff to help run your franchise business, please ensure that you have suitable contracts in place with them that restrict them from behaviour that could adversely impact your business, such as poaching staff, customers, or copying or stealing materials. So having the right contracts in place will place you on a better footing if you need to take action if this happens to you. We've certainly seen and experienced scenarios where this has happened in franchise businesses, where customers have been approached by former employees or staff members of a franchise. So it is vital that you put in place proper contracts with these that clarify what they shouldn't be doing to start with. So if something like this does happen at a later point, you can do something about it. So let's bring some of the points that we've been making about managing your franchise operation and some of the issues that can arise home by taking a look at a case study. In this case study, again, we look at a scenario that we have actually experienced where a franchisee has found themselves in difficulty in situations which have involved a whistleblowing scenario. In this incident, staff made serious allegations of harassment by a franchisee to its franchisor. The franchisor raised this with its franchisee, and the franchisee failed to do anything about it. The staff member then left the franchisee's business and brought a tribunal claim against both the franchisee business and the franchisor. The franchisor was able to demonstrate to the tribunal that it had implemented suitable training, systems and policies that advocated an environment in which harassment should not be tolerated or occur. The franchisee, on the other hand, was found not to have followed those policies or actually implemented them fully into its business, and therefore was found liable by the tribunal to that particular staff member. The outcome of that decision was not only financially difficult for that franchisor, but also resulted in terrible publicity for the brand as a whole, and in particular that franchisee being unable or finding it quite difficult in any way to sell on his franchise business at a later point in time. So these actions, or rather inaction, is really not the way to go. If there are policies that are implemented by the franchisor that help you manage your businesses better, it would be prudent to follow them. And now we move to the final section of our training that addresses franchisee crises and practical and legal ways to deal with them. We look at the latter stage of operation of your franchise, and in particular preparing for exit. We'll be covering the following topics: death or incapacity, client contracts, supplier contracts, ensuring continuity, next steps, and expansion plans and resource issues. Death or incapacity, unfortunately, is one of the inevitable outcomes for all of us someday, and to ensure the preservation of your business interests and continuity at what will be a difficult time for others, it's key that you put in place a will. Ideally, that should be done at the outset when you start to operate your franchise, but that is always not necessarily something that you think about when you begin. But you certainly should, at some point during the life of operation of your franchise, consider what happens to your business in these particular circumstances. And having a will make that whole process so much easier for those that you leave behind. Alongside that, from an incapacity perspective, it's also important for you to have in place powers of attorney that deal with your business assets if you die or become incapacitated, so that, again, those who leave them to can actually administer and have access to what they need to ensure the continued operation of the business. It is also key from a practical perspective to ensure that you update the franchisor with details of where your will and said powers of attorney, etc. are. Practically speaking, when these things happen, a lot of the time people don't actually know where the physical or digital copies of any of this information are, and that can substantially delay the whole process that needs to happen to deal with the administration of your estate. So someone needs to know where this stuff is and needs to be able to liaise with your franchisor so that it can become clear what's going to happen to the business. When your franchise agreement is coming to an end, it is important that the contractual relationships with providers, customers, lenders, etc. is maintained. You should take active steps to engage with those parties to ensure that there is continuity of the business post your exit. This must be made clear in the contracts that you have in place with those clients, providers and lenders, and that you are able to pass on whatever you've got to the potential buyer of your business. If you want to be able to exit and actually realise the investment in your franchise, having correct contracts in place will be a key part of that process and the actual sale transaction. Likewise, you should avoid entering into contracts with suppliers that contain prohibitions on transferring the agreement, either to the franchisor or to others in the franchise network. This again is vital to ensure continuity of service and continued operation of your franchise business once you are no longer part of it. And if you want to be in a good position to sell your business on to a third party for a profitable value, having that type of contractual documentation in place will be key. This is particularly the case when it comes to the use of IT equipment and software. Ideally, you should be using the IT provider that's recommended and required by your franchisor, and that helps to ensure consistency across the network in what systems are used. It also is something that will normally mean that there are client data or information included in those IT systems and services that others will need to access. So it's important that any IT providers are aware of third-party rights to use of and access to this data, and that you are then able to transfer that over to a subsequent buyer of your business and enable the business to continue to be operated easily when you cease to be a franchisee. So, what will be your next steps once you have sold your franchise business? As a franchisee, you are typically building up reputation in the brand, in the area where you operate. And that is goodwill that you would pass on to another franchisee who takes on the area when you stop operating there. This means that once you stop operating your franchise, you are prevented for a period of time from operating or being engaged in a similar business. That restriction does not apply for very long, but it is there to ensure that the incoming franchisee has an opportunity to benefit from the goodwill in the brand that has been built up in that area for a period of time. And after that time finishes, you can pretty much do what you want. These days, it is often the case that franchisees take on more than one franchise. They may start to operate a single unit or operational franchise and then decide that they would like to expand into taking another. If you are considering taking on another franchise, it is vital that you clarify what will happen to the staff in that franchise. And depending on how the acquisition is structured, it will depend on whether the actual acquisition qualifies as being a 2P transfer legally, which means that staff become part of your business. Now, that's the legal position. However, practically, the outgoing franchisee may have a good relationship with members of their staff, and in their absence, those staff may also leave the franchise business. So you should take steps to ensure that the business can continue to operate and to plug any gaps potentially in the talent pool to ensure a smooth growth transition. So let's take a look at a scenario which we have experienced again when a business was in the sort of preparing for exit stage and what happened. In this case study, there was the sudden and unexpected death of a franchisee, and his distraught widow, who had no experience of actually operating the franchise business, was left in the position of having to do so for a 3-month period at a very distraught time for her, having not had prior notice of what was going to happen. There wasn't a will, and so this meant that the probate process itself that was dealing with the individual's estate was lengthy, and this widow was overwhelmed by grief and still had to try and run the business in the interim, a business with which she had very little familiarity. Due to the pressure of having to do this and the circumstances that she was in and the grief that she was experiencing, the widow succumbed to sell the territory for a significantly reduced price in order to take the burden off her hands. So this scenario is an example which we were involved in of a situation that could have been avoided if a proper will was in place at the time that this happened. This would have meant that the process for dealing with the husband's estate would have been a much easier and simpler and quicker process than occurred in this situation. There would have been some certainty and support for the widow in dealing with this, and the business could have been disposed in a probably more profitable way than it ended up happening, in this particular situation. So I cannot stress again how important it is to deal with issues like this as early as you can. Having a will is a relatively straightforward process, and putting in place power of attorneys. You do it when you think about your personal life. It's important to also do it when thinking about your business as well. So to summarise, let's look at some of the key things that we have covered in our training today by looking at some of the Q&A points that you can now answer. How should you set up your franchise business? Ensure that you consider putting in place agreements between you and the partners in your business that clarify what happens when one or other of you leaves and what happens to their share of the business. What happens to my franchise business when I die or become incapacitated? Well, if you don't have a will, then that's a relatively tricky process, and it may just pass to someone who doesn't really want to have the burden of running a business at that time. So give some thought to who would be a good candidate to operate your business in your absence, and put in place a will and powers of attorney to give them the ability to do so in a simpler and easier way. What issues should you consider if you are thinking of buying another franchise? I mean, in this particular scenario, you need to look at some of the simpler things like who is going to be in the business to help me run it? Will I need more staff? Will the staff that are in the business that I am going to buy stay? And that's a practical question, not a legal question, because legally they could become your responsibility, but you do need to know practically if they're going to stick around. What other questions can you now answer? How do I preserve customer data and information for the incoming franchisee? Look to your contracts. In your contracts, it should make clear what position the new buyer will be in. Make sure you've got clear contracts with all your suppliers and all your customers and all your clients, so that it is clear that when you sell your business, they get rights to step into your shoes and continue as you were. What can I do when I stop franchising? Well, immediately you need to avoid doing something that is very similar or the same as what you do as a franchisee, and that's because in the area where you've built up a reputation, there will probably be another franchisee coming in who wants to take the benefit of that initially. So for a period of time, you need to do something else. What should I avoid to protect the valuation of my business and the network as a whole? Ideally, anything that's going to disparage the network. So if you or your staff are wearing the brand or driving branded vehicles or running holiday camps or classes wearing branded uniforms, they should be conducting themselves appropriately and not doing anything that might place the brand in an adverse position. So we have looked at a variety of franchisee crises, looking at both the practical and legal implications of those issues, from the very early considerations at the start of operating your franchise to those that apply on a day-to-day basis as the franchise grows and you manage it, and then to the things that can arise towards the end of the operation of your franchise when you are looking at selling it on, retiring, etc. All of these things can be managed well by you by putting in place the right contracts, steps, processes and systems at the beginning and getting the right advice. I hope that that's been helpful for you. Thank you for listening.